Everyone for coming along tonight. As most of you know, I'm John Barazio, the Managing Partner here at Wayland, WA. Just before we kick off, if you need to use the amenities, they're through the reception on the other side. There's toilets. In the event of an emergency, we also go in the same direction. There's a couple of that, so through the kitchen area or just around, just past the toilets, there's another set of stairs down to go outside. So hopefully everyone doesn't have to use them, and we should be right for tonight. Just thought I would break some news for everybody here tonight. Today the AFR released their top 100 accounting firms across Australia, and Wayland Australasia network went up a couple of places, so we're now number 15th across the country. So I think that's a pretty good result. Just so that you're aware of a couple of stats, we've got 92 partners and about 500 staff across the country, and national revenues around $95 million. So we might appear small in WA, but across the country we certainly punch above our weight. You would have noticed on your seats there's a little flyer there for Give a Feed. That's a friend of mine who was on board at the Perth Football Club 9 years ago. The charity is designed to help families in need have a feed at Christmas, so that's why it's called Give a Feed. It's all done through Food Bank. So if you feel it within your hearts to donate to that cause, he'd be very grateful for that. I think over the years they've done something like 80,000 meals to help out on Christmas Day for those families that can't afford to feed themselves. Now on to our session today. We've got I'll just have to go back and find my notes of who's meant to be presenting, but Nicole is here today to present for the session. Today's session is on family law and family business assets. So the reason we decided to run today's session was earlier in the year we ran a post on Facebook and LinkedIn about family law matters, and that was the highest rating post that we had for the year. So we thought it was good to get somebody in who knows what they're talking about in this space and hopefully educate about how to protect their family members and friends if they're in that situation where they need family law. So today we've had a few changes in speakers. We have Hayley, who's now backing up Nicole, who was backing up Georgia, and there was obviously Andrea as well, who has. So I'll hand you over to Nicole, who will take you through the session, and if you've got questions, I'm sure we'll take those throughout the session or at the end.
Either, yeah. Thanks for that. Yeah, so that's, as I surmise, we just call that 2020. So every time something happens now throughout the year, we go, yeah, this 2020 just keeps on giving. So that's pretty much what's happening. Thank you to Wayland for having us. What a tough gig. You guys get to come here early and get out to that beautiful view and get food and drinks and then get told to come in and sit down, but I'm glad to see you all get to still have wine, and we'll try and keep it as short and succinct as possible. So family law and business future-proof your assets is the topic that we've got there tonight. I feel like that's a little bit of a lie, because 100% future-proof assets from the family court. The family court is a very powerful beast. It has wide-ranging powers and is a discretionary jurisdiction. It can pierce the corporate veil. It can undo transactions. It can do many, many things. Many people think the family court's not very powerful, but I would disagree and think that they actually have, very many powers when you look at the different jurisdictions that we deal with in law. But what we're going to talk to you about is future-proof, what's the best insurance you can offer, and if you're acting for business owners in various different scenarios, how can we assist them through the process if they've separated. So I am not great with technology. Let's see if I don't break it. So Carr Co is, just really briefly, a boutique family law firm established by William Carr in 1995, and we currently have 13 lawyers. I think we might be one of the largest, if not the largest, family law firm directors on screen. You were going to have the first two, then you're going to have the next two, and just 2020. The rest of our team is up there, including Mr. Carr on the left, who's about to retire towards the end of the year. My champion tonight is Hayley Ellison, our senior associate, who stepped up to the mark, and she'll be talking to you shortly and starting off the presentation. And Hayley and I have both been practicing exclusively in family law, myself for 15 years and Hayley I think for 10 now. So hopefully tonight we bring you 25 years of combined knowledge and some information that's helpful in your individual workplaces. So Hayley's going to start by talking to you about how the business is treated in family law matters, briefly in terms of property and valuations, and then I'll take you through 3 different scenarios as to whether you're acting for the business owner, the one that's not really involved in it, or if you're acting for someone who's been working in a business that has been jointly run throughout the course of a relationship, and what's the best thing to do for them in those 3 scenarios. You'll have to forgive me, I've just stepped into the presentation for tonight, so I will possibly not do it justice, but I'll do my best. So the family court, in terms of businesses and how it treats properties, the value of each party's share in the company will be determined by the court by considering the company's share structure and the structure of the business. The family court, in its wide discretion, has the ability to pierce the corporate veil. So it's important to remember that people making throwaway comments such as, I've got a business, it's protected, don't worry, it's outside the asset pool, is not actually correct. The family court is actually able to call that up, keep that asset in the pool. So any clients that come to you and say that they're potentially hiding assets by putting them into companies and things like that, that does not actually work. So it's not worth spending the fees. The fact that an interest is not transferable does not necessarily mean that it falls outside the definition of property in the Family Law Act. So I'll go through, sorry, get out the slides. Yes, okay. According to the Family Law Act, property means, in relation to the parties of a marriage or either of them, properties to which those parties are, or that party is, as the case may be, entitled, whether in possession or reversion. In relation to parties in a de facto relationship, or either of them, property means to which those parties are, or that party is, as the case may be, entitled, whether in possession or reversion. Now, we've put a few case examples in here. When it wants to go, oh shoot. Let's go back. Okay. So a few case examples in there. So the case of Duff and Duff is the authority for the proposition that shares, even in a family company, are within the meaning of property. Businesses are regularly discussed as though they are a separate legal identity from the parties. This is not always the case. In this regard, the full court stated, it seems unnecessary to attempt to set out a catalogue of what property may include in the context of legislation. It is sufficient for the purposes of the case to say that property means property both real and personal and includes choices in action. In the other case of Miller and Miller, it's an authority for the proposition where the business is operated by a partnership, the interest in that partnership. And in Harris and Harris, the corpus of a trust was found to also be property, where the husband was both the beneficiary and appointer of the trust with complete and unfettered control over the trust. And in Best and Best, it was held that an interest of a partner in a law firm was property, even though it was not a transferable interest. So, just hopefully not go too many. So in determining the value of a business, which I'm sure is a question that clients often would probably come to you with, there are a number of different methodologies which can be used to value the business. Some of the methods are capitalisation of future maintainable earnings, the value of net tangible assets or on an ongoing concern basis, discounted cash flow,
notional realisation of assets, and capitalisation of future maintainable dividends. So the most common one I would say that we see is capitalisation of future maintainable earnings. But it's important that when clients come to you and come to us, that we consider the type of business that they have when we make recommendations in relation to what type of valuation they should get. It's important that they get this advice rather than going down the path of perhaps taking the wrong methodology to have their business value, to avoid spending money on something which is actually not likely to assist them and may result in their business being either overvalued or undervalued. So we've had issues previously where some people have come to us with valuations which have been incorrectly undertaken, and the valuation of their share in the business, for instance, has been significantly higher than it actually is. So it's important, and it's a good way to save our clients money. And this one, it's over to me.
Just on that valuation, so because sometimes, say, in a typical example, like husband ran the business and the wife didn't really understand it, and say about one valuation was done, and done by the husband, and he said, it's worth 100,000. How would she know? What would she need to do, do you think?
So when we talk about valuations in the family court, we talk about single expert reports. So ordinarily that is an expert who is jointly agreed upon and jointly instructed, and all communications are copied to all parties, and it's done pursuant to the family law rules. So in that scenario, if one person's already got a valuation, what would we do? If we were acting for the person who's presented with the valuation, and you don't want to necessarily go through a re-exercise of evaluation, and they can be very expensive subject to the business that we're valuing. I've seen valuations ranging from 5,000 to 10,000 to some costing 40,000 to 50,000, depending on the business and the volume of material and asked and needing to be answered and looked at. So if I was acting for that person, got the valuation that had been prepared, I would say, look, let us get our own accountant who does do valuations, and let's have a look at it. And if we went through it with our own independent person and they were satisfied that it seemed to all be accurate, we could use that valuation for the purposes of negotiations. Wouldn't be binding on the family court. If the husband got the valuation and the wife says, I don't accept it, the family court would say, well, probably shouldn't have wasted your money, buddy, and off you go to get a single expert witness valuation. So we will always, general starting point is don't go and spend your own money on a valuation unless you think that that's actually going to help resolve things quickly and the other side's going to accept it, because you may just be pouring money down the drain because you're going to have to go through the single expert process. Doesn't mean that we don't get people like are in this room and financial people involved at an early stage to look at it. We often get people working with us and collaborating with us, which Hayley will talk about, in terms of looking at the financial path of a single expert witness valuation, or can we come up with a figure that everyone's comfortable with for the purposes of negotiating? It depends on the business type. A doctor who is a medical specialist and, let's say they're an oncologist, and basically if they weren't there, their business wouldn't exist. 9.9 times out of 10, that business doesn't have any goodwill. It's not. The business is going to be the value of what's cash in bank, and in terms of our assets and liabilities schedule, basically what's in the financial statements. Say for the medical equipment, might need a plant and equipment valuation because we might not accept the written down value in the financial statements, which might be a bit low for depreciation purposes. So
but we don't, as a starting point, say that the client should reject the valuation. Because in a lot of cases when parties are going to mediation, the valuation undertaken by, say, the one party's accountant is actually sufficient for purposes of mediation. They don't need to go to the expense of a single expert witness. And where possible, we try to get clients to accept valuations which are fair and based on the right documents.
We can talk about like so many different, so that's why I said try and keep succinct. You've got to tell me to stop talking, guys, when you want to get back to the line, because I'll just keep talking about family law for a while.
Would it be fair to say though, with the valuations, unfortunately I've seen far too many divorces over my time, the first thing for the lawyer to do is actually say, look, I appreciate that you're bitter, and twisted and pissed off, and it's not fair and it's not reasonable. However, the family law court will deal with facts and figures and numbers. Otherwise, you go down these rabbit holes of valuations and IAs being appointed to investigative accountants and all that type of thing, when in reality, one or other of the parties is just really aggravated and pissed off. I imagine as a lawyer, that dealing with that bit and getting them onto a relatively rational period will be one of your biggest jobs.
Yes, yeah. Except when they say the business is worth more, you go through the valuation with them and say where do you think the valuation is incorrect? Where do you think there's more money? For instance, some clients might fall, oh, he's hiding money. Okay, well, when you put together, this is how much income he received and it was deposited in this account and is continuing to be deposited in this account. Where else do you think it could be? And how do you think the equipment suddenly tripled in value since you've separated? We try to possible, because it does go from the stage where someone's not involved in the business at all, but then they suddenly become an expert on it post-separation.
We've got one at the moment like that, and we can end up to $1 million in legal fees quite quickly.
Yeah, and that's a problem.
And
We've got to try and
that's
and it happens often.
it's scary, and it's quite frankly outrageous to end up with that amount of legal fees. There's a really simple pathway about how family law matters are dealt with. But this is more about business stuff in terms of, how do we address a family law issue? And it's a 4-stage process. The first stage of the process is identify all assets, liabilities and financial resources in the name of each party, any entity they control, any family trust, business, etc. So that's why we start with the schedule of assets and liabilities and looking at the valuations, but there's easy ways to cut through the dross. One of the bigger problems as to why sometimes you get that sort of attitude is if one party is withholding information and then the other party starts to think that there is that chest of money, or it's under the mattress, or it's in someone else's bank account, or it's been transferred to the Cayman Islands or whatever, which sort of
still looking for that. Has never arisen.
Lots of people are still looking for it, which sort of brings me into the next slide, which is about directors and shareholders' rights, duties and obligations in the event of separation, which then leads into the 3 scenarios, which I'm going to briefly touch on. And the most important thing, no matter who you're acting for, whether it's the business proprietor or the spouse that has nothing to do with the business, is that everybody gets informed and that everybody informs each other. But the part of the problem is that sometimes people are a little bit cagey about doing that. And so we have a duty of disclosure in family court cases. And each party has to disclose all documents in their possession, custody or control that are relevant to the proceedings. And so you lead into those problems that you raise where one person doesn't just hand over the documents. Because normally what we would do is, if someone's come to see us, well, let's get the documents, let's get a schedule, let's get to mediation, let's settle. And we do a standard letter saying, here's the parts of the family law rules, 13.1 and 13.2 that require you to provide X, Y, Z documents. Please, could we have those within 14 days? Sometimes we'll say if you need to give us an authority to your accountant to get them directly, please let us have that authority, just basically hand them over. And so sometimes that's where those problems come in, is that people don't give them, and then people start to think, oh, what are they hiding, what's going on? So it's important to understand who you're acting for, what the rights are. If the wife hasn't been involved in the business and the husband's run the business, but the wife is a director of the company, she's entitled to the documents. She can contact the accountant and ask for the documents. They need to hand them over. You need to be aware of the Corporations Act, and we've said look to Section 247A, but we also need to look at the individual constitutions for companies in terms of what's in those. But there's ways and means of getting the documents, and who has the capacity to call a meeting? If you're acting for the wife who hasn't been involved in the business but she's a shareholder and she has a right pursuant to the Constitution to call a meeting, try and inform yourself, try and move things along in that manner. So that brings me to the 3 scenarios. So what do you do in the event of a dispute? So scenario 1, if your client is the business proprietor. Scenario 2, if the spouse is the business proprietor, or not the business proprietor, I think that should be. Scenario 3, if both parties are business proprietors and have run the business jointly and then have a separation. What happens then? Do they continue to run it jointly? What do we do? So your client's a business proprietor, and you guys might deal with a lot of these people, or you might deal with scenario 2. Generally speaking, it's one or the other. In my 15 years of practice, I haven't seen too many businesses that are like hands-on, jointly run, and they need to deal with who's going to continue to run the business. It's normally one or the other. So you're acting for the business proprietor. What do? Business as usual. Don't change anything. So if that person comes into your office and says, right, I want to get them to resign as shareholder, I want to appoint a different director, I want to transfer this, I want to open new bank accounts, I want to do X, I want to do Y, don't do it, because then that just raises the suspicion that we're talking. Don't change anything. Don't change any structures. Provide the information. Get to a mediation with an assets and liability schedule. Try and reach a resolution in that regard. Changing structures, entitlements, permissions, all of those sorts of things, you're catapulting yourself into the family court. Because if you've got someone who all of a sudden there's a separation and they stop doing things that are outside of the ordinary course of business, and they start to change structures and change bank accounts, or the other party used to be able to access the bank accounts and see what was going on, and now they can't. That's where they think something's going on, something's not right, I can't see what's going on anymore, I'm going straight to the family court to deal with this. And so those sorts of actions and activities by the business proprietor just ultimately catapult you into somewhere you don't necessarily want to be. That's when legal fees can start to really run up in relation to your comments there before, because you have a load of interim applications and arguments about permissions and structures and reversing transactions and ongoing dealings in that respect. So just keep running the business. Provide the disclosure, including anything that's reasonably asked for that falls within the rules that I mentioned before, and just continue to do everything in accordance with the Constitution. They can't come under scrutiny then, and the process can be simple. It can be the disclosures provided. Does there need to be evaluation? Don't necessarily need the valuation, and that's agreed. Everyone works towards a joint assets and liability schedule. Everyone has some settlement discussions. Because if in scenario 2 you're acting for the person that hasn't been involved in the business, we say act quickly and get informed. So that comes back to you still have access to the information if you've had it before. Inform yourself about the Constitution, inform yourself about the rights that you have if you are a director or shareholder, get on the ground kind of thing. But what we have to invariably tell those people is the second dot point up there, which is consider injunctions and or undertaking. Accesses, and they can see that everything hasn't changed and they just keep monitoring it. Nothing needs to happen. But what we do quite often have to do, because business proprietor in scenario 1 has done all the things that we say don't do, and they've changed all of the permissions and started to hide information and not disclose, well then that's the catapult. Any decent family lawyer would be saying to the spouse that's not the business proprietor, you need to make an urgent application to the family court, you need to seek injunctions restraining any dealings safer in the ordinary course of business, and you need to seek to have your permissions to bank accounts re-established if they've been cut off, and if they haven't, we seek very specific disclosure orders about quarterly, etc. We get authorities to speak to accountants, and we have to make sure that we can be involved in the business running if we've been cut out of it and we previously were before. So that's where you end up in the family court. So you've got those really polar positions.
Just in relation to injunctions, how often have you had to use Anton Pillar orders previously? Or?
Yes to Anton Pillar orders, but not common. There is a very high bar to get an Anton Pillar order. Does everyone know in the room know what an Anton Pillar order is?
Sounds really impressive though, mate.
So an Anton Pillar order is an application that you you execute an anti-pillar order without the other party knowing. So you make an application to the court on what we call an ex parte basis, which is in the absence of the other party having any information about it. And you do those in very extreme circumstances. If you think that people are starting to delete hard drives, shred documents, or if they're going to destroy the evidence. And sometimes we have to do it in cases, and we had to do it in a case once, and the anti-pillar order was granted, where the other party just simply wasn't disclosing, and we ended up making an anti-pillar order and saying application saying the only way we're going to get this information in family court is if we can turn up to the office of the business and seize the documents that are there and get your anti-pillar order normally includes getting copies of hard drives, of computers. You have to line up IT people. When you get an anti-pillar order these days, you never used to, you have to have an independent lawyer present who has to keep an inventory of everything that's seized or copied, and it's a very high bar. So it's done. It's not done frequently in relation to the anti-pillar order.
You also have to give an undertaking as to costs when you file for one of those. So if you do file for one and you're unsuccessful, or one's executed and it's unsuccessful, your client is on the hook for costs.
Yes.
So we don't routinely recommend them. We try to talk clients down off of those because it's a very high risk.
Very high bar, high risk. Yeah. Sometimes high reward. But there's been a few cases where the anti-pillar order has produced very high rewards in terms of things that would have probably never been uncovered in a case. But the injunctions and undertakings all the time is the answer to that. We try and avoid the injunction by writing to the other side promise to the court that you won't deal with the business save in the ordinary course, and you won't change structures or further encumber or what have you. Perhaps without X amount of days notice is a sort of more standard wording. And if people don't give the undertaking, you advise the client to go directly to court to get the injunction. You don't know what they're going to be doing in the business, and if you don't have access to the information and they're not giving the information, that's where you're acting for the spouse that's not involved in the business, and you want to protect the business assets. And the thing about family law matters is it's much easier to preserve what's there than try and uncover what's done. That's not to say that we can't uncover what's done, and someone sent $100,000 to the Cayman Islands or transferred $100,000 to an aunt or uncle or long lost relative, and there's things and powers that the court can do to reverse those transactions. But the far better position, and why that's the position we say for scenario 2, is to preserve the asset pool, because it's much easier to say, there it is, let's keep it like that, let's keep the business running, we don't want to impact the business, but let's not let things happen that we don't know, that we find out later if we have to sort of claw back, because that is more expensive as well. Does that answer your question? Scenario 3, not very common. Has anyone in the room acted for someone who's been in a business that continues to run jointly, or yeah? Did they do it well?
Yeah, reasonably well, yeah.
Yeah.
But then at the end you had to decide which party was going to take the business.
Yeah.
And that caused more issues than the actual running the business.
Lots of issues.
There was actually they traded from 2 different premises, so that kind of one take control of one premises, the other.
Okay.
So
that's a good. Both parties running a business, what do? If they've both been hands-on and they don't want to continue to be in the business premises at the same time, 2 business premises, 1 at each one, perfect, great interim solution until the final property settlement's resolved. Some other options are, I'm working Monday, Tuesday, Wednesday morning in the business office, you're working, split it. It's trying to make sure that you keep the tension out of the business, that if the 2 of them want to continue to run the business, that they've really got to be fairly amicable to make it work and to do it well, because you want to make sure you've got that staff retention and that you're not losing the staff in the business because of, husband and wife both turn up to the office at the same time and have, an argument about whose day it was supposed to be or what have you. So you can have that by agreement or by court order. So Agreement's always better if you can figure out who's doing what and how they're doing things, and 2 separate premises, great. By court order on an interim basis, if the 2 of them can't agree, you have to have the court decide cases, because the court really struggles and tries to avoid those interim hearings because they don't like to predetermine the outcome. So if you've got a scenario that you're talking about over here where they both want to retain the business, of course they both want to continue to be involved in the business. And one of them doesn't want to leave because they think that's going to disadvantage their case to continue to retain the business, especially because we're going to take 12 to 36 months to get through a family court case from beginning to end. So the court will try and, if it's workable to do it by court order so that they both continue to be involved and the court deals with it on a final basis where evidence is cross-examined and actually tested, they'll do that, because otherwise determining it on an interim basis, which we call on the papers only, and that evidence isn't tested by cross-examination, is really difficult to do.
There were 3 partners, and one of the partners got divorced, and the wife was coming after information and injunction and all sorts of interesting things, but it was affecting all 3 of them, although 2 of them had absolutely nothing to do. So you ended up saying, well, there's almost needs to be someone representing the business, someone representing the 2 partners that aren't actually getting divorced, so their rights and that was really difficult.
And sometimes the other business proprietors do have to get involved in the proceedings
Almost
to a certain extent. Yeah. Or get involved in terms of requests or things that are being made by the other
they nearly
side.
appointed their own lawyers to deal with it.
Yes, and that quite often happens as well. So they're the sort of 3 scenarios, and it's a really brief overview, and I think I've already gone past our sort of chat to you briefly, let you guys get back to your wine time. I'll let Hayley talk to you really quickly on to sell, to transfer, to restructure, how can we collaborate with you guys, and then I may as well just talk to the last slide while I'm here in terms of the scenarios, and then Hayley can finish off with that and we can just do any questions. The last slide when it comes up is about binding financial agreements. So that's another topic in itself. Can you figure out now that I can talk? And I can talk about binding financial agreements for probably 2 hours because they're a really difficult area of law and there's a lot of technicalities about them. But what I wanted to say to this room tonight is binding financial agreements are an option for people to attempt to they can be entered into before a relationship, during a relationship, and we do them post-separation, the actual settlements. Before a relationship is the best insurance policy that we can offer to people in terms of if something happens and someone separates, that what's in the binding financial agreement, normally identified as people's separate property, remains their property. A lot of wealthy parents, sometimes business partners, things like that require binding financial agreements before businesses sometimes are started, and the binding financial agreement can deal with just the business assets, and then whatever husband and wife do in terms of their own personal assets, so be it, and that's open to the family court, but they can be confined to just the business, and sometimes people want that as part of shareholders agreements and things like that when they're establishing businesses, and key man policies and all of those sorts of things that you guys are probably familiar with when businesses are established. So that's another option, but we were talking more about what to do if we were in the family court tonight, but that's something also to consider that is another big topic in itself. I'll let Hayley talk to you really briefly about how can you guys help us and how can we help you, and then you can all get back to your one.
Okay, so we work a lot with accountants and financial planners when it comes to assisting our clients. A lot of the time our clients don't really want to deal with collating their paperwork, liabilities, or assist us in that regard. And a lot of the time we find accountants are of tremendous value to us and to the clients. Clients also sometimes can have a misconception or misunderstanding of some assets in the asset pool and potential tax liabilities which they believe that they may be incurring or likely to incur, and sometimes they want to put them in there just because. So we often will get an authority from our clients and speak directly to accountants and get the documents from the accountants. If If we have busy clients, it actually works a lot better because accountants know exactly where the documents are, can answer our questions very easily, and often have already prepared a lot of the information. Sometimes the accountants actually have schedules of assets and liabilities already prepared for clients, so we can use them and save the client having to go to the expense of us also preparing a schedule of assets and liabilities. Otherwise, accountants also assist with valuations in circumstances where one party has got a valuation. Sometimes if they have their own accountant, the other party has their own accountant, the other accountant will have a look through. They can make some recommendations about some possible questions that can be asked to clarify that valuation so we can still use it. And they can also make recommendations in terms of other documents that we can look at to get a better idea as to whether that valuation is actually worth relying on. Because as we said before, if possible, we would like to rely on a valuation which does stand up and is sound in terms of the documents and the methods. As we've had circumstances where, and I've had a few clients where we send them a Form 13 financial statement and they don't want to fill that out because it seems too difficult. And accountants are fantastic at helping us with that. And they are, well, brilliant with numbers, so it's actually fantastic. So we actually get a lot of assistance from accountants and financial planners for all of this, and I think that that's an excellent service for clients as well.
And it's possibly the worst family court form out of all of the court forms. Like clients just look at the Form 13 and just go, what the, it's quite daunting, but it doesn't need to be. Especially where for the bulk of it you can just put C schedule attached and attach the assets and liabilities schedule to the back of it, but it can look an extremely daunting form to clients, and clients who are very busy and want to just get on with business.
Hayley, just a quick question. If you've got a young couple separating and she was receiving a distribution from a family trust or lineal descendants family trust, do we exclude them from the Form 13, or because they don't control the trust but they do receive distribution?
We would include it generally as a distribution as part of the income, would we not?
It's in the income section of the So you would do your Form 13 on the income section on the most previous financial year or more up-to-date information if you've got it. So it's definitely part of the income. You might want to put in Part O at the back as to whether it's going to continue is another story, because especially if they're not the person that controls it, they may not continue to receive it post-separation.
But in circumstances where they're separation, it would be somewhat deceptive to all of a sudden stop receiving that, because there's also issues where parents will stop paying those funds because separation is happening, and if there was an understanding during the relationship that those funds were going to continue to be distributed for some time. So where possible, disclose and get your clients to be disclosing everything to you and to us, and we can always discern what needs to go in and what can stay out, but most of the time everything has to go in. Otherwise, in terms of family court orders, benefits to transfer relief, CGT relief, rollover relief, and assignments on loan accounts. But otherwise, they draw a line in the sand. They end the financial togetherness of parties. It means that parties can move on, save their own money, generate their own income, purchase property, and do things without their spouse or their de facto partner. And it means that we, as best as possible, try to ensure that there's no coming back for a second go. And the ways to avoid someone coming back for a second go are to make sure that there is full and frank disclosure, and that the other party is given that disclosure, so that there isn't issues where people come back in 5 years' time and say, I didn't know you had $1 million sitting in Cayman Islands. Whoops, must have forgotten to disclose that. So
that's enough to restart a case.
Yeah.
Okay.
If you look at, so you get to the order stage and they're all done, signed off, everything's done, 6 months down the track, some of these things take a bit longer to unwind properties and that type of thing. If you say, nah, I am not signing the transfer, because there's actual technical documents beneath the court order that need to be signed. If they don't, do you have to go all the way back to court and get a court and get him or her to be forced?
Short answer, yes, but fairly simple application. So one of the standard orders that will go in any sort of consent order is that both parties do all acts and things and sign all documents necessary
That's
to
in
give
there.
effect to these orders. And if that means which is contemporaneous with a payment, or if it's resigning from a position in an entity, or signing the rollover documents for a super fund, or whatever it is, and they don't do it, and they haven't done it within the time frame that's ordered, because your orders have been drafted properly, and orders binding if it requires someone to do something within a certain period of time. If there's no time frame, then technically it's forthwith. And if you go to the family court and say, family court, here's the order, it was made on the 25th of November, it was meant to happen in 14 days, they haven't signed it, you can seek an order pursuant to section 106A of the Family Law Act for a registrar to sign on their behalf.
Oh, so a registrar would sign on their behalf?
If they,
Could
yes.
sign on
They're
their behalf.
satisfied that there's an order, it hasn't been complied with, and they're not, sometimes they'll say, sign within 7 days, sir or madam, and if not, I'll sign. So yes, you have to go back to the family court, but if it's a clear breach of an order, it's a fairly simple application, and a registrar can be ordered to sign on someone's behalf.
And sometimes we build into orders as well that in the event of non-compliance, if that is an issue which has cropped up throughout the case, you can insert provision to say that in the event that they don't comply, that then there's liberty to apply, or that someone else can sign on their behalf if necessary. So we try and preempt, but obviously we can't preempt everything, but we try to keep those orders in there so that we can keep people accountable. Or you can hold off a part of a cash payment, say to the other party, until all of the transfers and all of the documents are signed. So that way there's incentive.
Sadly, in Western Australia, other jurisdictions no, but sadly in Western Australia, the family court won't let you include the 106A order at the outset. They'll only let you include the liberty to apply, and then they'll do it after the fact. Other jurisdictions let you do it in a final set of orders. So sometimes we get orders from Melbourne and Sydney solicitors, and they're going to be lodged in Perth, and we go, sorry, the family court's not going to make the 106. They will do it if someone doesn't comply.
Excellent.
Yeah, which is why we try to keep the time frames as tight as possible, so that there is not that elongation of proceedings and transfers and things like that, so everybody's on the hook.
We've gone over time. Sorry about that, John.
Thanks.
I told you we could talk and talk and talk.
Informative talk, informative talk.
Thanks. If I can get everyone to put their hands together for a couple of quick questions, things that come up from time to time as an accountant. I think might be scenario 2 is probably the one that comes up quite a bit, and that's where one person's running the business, and then all of a sudden my ex-spouse has just emptied the bank account. So what do you do?
Do an immediate letter to them or their lawyer saying return the funds within 24 hours or we file, and also sign an undertaking that once the funds are and if they don't, you file an application, you seek the immediate return of the funds. So it comes back to that preserve the asset pool. So if you've seen it go, you get it back within days or as quickly as the court will list it. And for all its faults and woes, the family court does deal with urgent matters very urgently. And if they deem it urgent, so you can get that money back quite quickly and then get restraints on withdrawals or make accounts to sign or things like that thereafter. Grace and I had a case, when was that, Grace? In October, and the husband was about to leave the jurisdiction on the knowledge that the wife had. He was about to fly to India, and the asset pool is likely to be circa 7 million, but 6 million's in Indian bank accounts. And if he left the jurisdiction, and it's a long marriage, and like the outcome of the case 50-50, it's like a 35-year relationship, etc. So if he left the jurisdiction, it would have completely thwarted our client's claim for 50% of the asset pool if he never came back. So we filed at 2 o'clock in the afternoon, and we were in court at 9:30 the next morning on an ex parte basis, so that's the one in the absence of the other party, and the orders were made, and he was put on the federal watch list and he wasn't allowed to leave the country.
Excellent.
So
He was really happy about it.
he was really happy. She was really stoked about it. So there's, for all its faults, when it's urgent, it's urgent.
But you couldn't actually freeze the money.
Not on
in India.
Not on an ex parte basis. Our application was actually, if he transfers 50% of the balances from India over here into a secured account, off you go, we don't care. But that part hasn't been heard with yet. The court deals with the really urgent stuff on an ex parte basis, which was don't let him go, because we've still got the person now in Western Australia who controls the money. But once we've got enough that's protected, we don't mind, off you go, travel wherever you like. Yeah. Sorry. See, you asked me one question and then I tell a long story.
Does anyone else have any other
asked
questions?
back again.
Just a really quick one. You spoke about Miller & Miller earlier in relation to partnership. Is that the partnership assets or the interest in the partnership itself?
It's going to be both, and it's going to be whatever that partner's share is that would be ascribed into the assets and liabilities schedule.
Right, so the partnership assets will be dealt with, so liabilities of the partnership come before their interest?
Yep.
Okay.
And that would need to be valued in that manner. Yeah.
Thanks.
Just one last one. The difference between, if someone was offered, $20,000 a month for 10 years versus taking the lump sum, which way do you sort of sway? Do you tell the client, take the money up front?
It depends on the capacity. So it depends on the case. So if you've got an asset pool where it's all wrapped up in a business and the business might have a great income, but we can't identify any lump sum amount and there's no borrowing capacity, then you're going to have to advise the client to take a payment on terms. Clients will always prefer the upfront payment, but if it's very clear that the upfront payment can't be made, then there's many cases like that where it's it's an income case, and I've got one at the moment. The businesses have got a huge value, but where do we get any money from to make the payment? And so the payment is going to be on terms.
And that's after tax they receive, or do they see gross? Gross, and then
so then that's where we work with accountants and financial planners, coming back to that slide, to make sure that we deal with any contingent tax liabilities in the assets and liabilities schedule. So if someone has to draw, for example, from retained earnings to make a payment from the business, and then there's top-up tax or whatever on that, we want that figure calculated by the accountant. We want it in the schedule, brings down the net position, brings down the cash payment. So we've got to make sure all the contingent tax liabilities are in the schedule, and that's the importance of that collaboration and the disclosure and working with accountants on all of those sorts of things as well. Because it's not always the values that you see, it's what's going to happen. If things need to be sold, sale costs will come in. If shares need to be sold, CGT will come in. So the sort of leading case in that is the matter of Rosati that deals with that.
Excellent. Thanks, Nicole and Hayley. One last round of applause. Just quickly before we invite you out on the balcony for more drinks, we've got our Christmas event coming up on the 11th of December, so keep an eye out for that invite. It'll be out here on the balcony at 5 o'clock on a Friday afternoon. Hayley's got some flyers there as you're leaving, so please take one. Just a quick one, Walk Wayland is passionate about running these events. We want to see business done better, so we hope you can make it to the next one that we run early next year. Otherwise, thank you for your attendance and hope you had a good night and learned something from it. See you shortly.
All right.